is written. And the second flavor, which is what we're going to be talking about tonight, is even more serious, and that is the Supreme Court derelict in not correcting law, which is clearly not in the Constitution, by not taking the case? And our two guests, well, the first is Dr. Edwin Vieira. Dr. Vieira is the author of The Pieces of Eight, The Monetary Powers and Disabilities of the United States Constitution. And the second book that he's the author of is The Sword and the Sovereignty, The Constitutional Principles of the Militia of the Several States. Dr. Vieira is one of the country's most prominent constitutional attorneys. He's had 4 of his cases reviewed at the Supreme Court, and he won 3 of those cases. Our other guest is Mr. Tom Selges. You've met him before. And Tom is the Constitutional Advisor and Chief Information Officer for the United States Bill of Rights Foundation. Tom and Ed, thank you so much for taking the time to come on the show.
Good to be with you.
Ed, let's start off with you. What are the responsibilities and duties of the Supreme Court as you understand them to be?
Well, constitutionally, the Supreme Court is the highest appellate court. And one would expect from Article 3 of the Constitution, which lays out the types of cases that can be heard, that its main responsibility would be dealing with constitutional questions, simply because those questions are going to arise in any limited government on a fairly regular basis. So that's its primary responsibility. Then its secondary responsibility is to deal with statutory questions, again, as the final arbiter in the appellate system. Again, for the reason that, especially if you're talking about federal statutes, those are going to be applied across the country, and we have a system of courts throughout the country that can decide these cases essentially independent of each other, either in the federal system, district courts, and the appellate courts, or in some cases in the state courts those questions get decided. And then you'll have disparate opinions coming up on interpretation of the statutes. You'll have disparate opinions coming up on the interpretation of various constitutional provisions, and there has to be some mechanism to bring those conflicting opinions together in some way, harmonize on one side and exclude on the other. So it has a very important role to play. Of course, it has a difficulty that as society has become more complex, we've had more statutes passed, certainly, which then also raise more constitutional issues. More cases are coming before the Supreme Court every year. The size of the court hasn't expanded, but its caseload has multiplied terrifically. So you have imposed on it, besides the legal responsibility, you have this very heavy practical, or what I would call almost physical responsibility, if you look at the amount of paper that is generated in that caseload.
Now, is it fair to say that this caseload has increased so much because of ambiguous decisions, improper decisions that the court has made in the past?
Oh yes, I would say so. They have a doctrine that they tend to apply, that they don't want to give advisory opinions. They don't want to give an opinion when an issue is considered not to be ripe, when some party doesn't have the necessary element of standing and so forth. These are essentially avoidance doctrines. There's a certain amount of constitutional basis to them, but it gives them the opportunity to avoid opining on a particular issue. And therefore they try to narrow as much as possible the scope of the opinion they write. Now the difficulty is that often these opinions are written in ambiguous terminology, directly or indirectly, and then of course when that gets to the lower courts, how is that going to be interpreted? Well, lawyers on one side will play it for all it's worth in this direction, lawyers on the other side will play it for all it's worth in that direction, and then we go back through this cycle again of disparate opinions appearing in the various lower federal courts or in the state courts, and those now trying to get up to the Supreme Court for review and a determination of what it means. I'll give you the example we were talking about earlier before we went on the air. In the firearms field, United States versus Miller, 1939 Supreme Court decision. It took them 70-something years to finally decide the Heller case and then the McDonald case. 70 years in an area in which there's been a tremendous amount of statutes enacted all over the country, federal, state, even local ordinances. It took them 70 years to deal with a Second Amendment issue. So how long will it be now for the determinations, the ambiguous determinations in the Heller and McDonald cases to percolate down through the lower courts and come back up through?
And just remind our viewers what the Heller and the McDonald cases were.
The Heller case ruled that the District of Columbia regulations on handgun ownership, that a person essentially could not get to own a handgun, keep a handgun in his own home for personal protection, that those are unconstitutional. And the McDonald case extrapolated that determination to the states by applying it through the 14th Amendment. And of course what that then did was generate a tremendous amount of further litigation in those same cases. I think Mr. Heller has been through one or two further iterations in the lower court, still doesn't have his handgun in his home.
One of the things that comes to mind about these decisions is that the court, in many cases, lacks unanimity. Is that the right word?
Exactly.
And I mean, the fact that they have to decide these things 5-4 means it's unclear even to them, you know, what the law is. How are citizens supposed to know what the law is?
Well, it's extraordinarily difficult because, of course, 5-4 decisions are always, how shall I put it, supported by and sometimes rancorous analysis back and forth. And many times it's an invitation to attorneys at the lower levels to use the dissenting opinion to try and get the lower courts to give them a decision that will then undermine the majority opinion to force that back into the Supreme Court. And there are a number of instances where that's happened in a very short, relatively short space of time. So there's one of the great difficulties, and I think it's become so, the constitutional law has become so encrusted with doctrines that were invented by the judiciary that find no basis in the Constitution whatsoever. And these things can be played for all they're worth by clever attorneys, that it really is a rat's nest. The element of vagueness in constitutional law has gotten to the point where, what was the expression, Supreme Court opinion was like a railroad ticket. It was good for one day only until the next sitting of the court. And I think that was under Charles Evans Hughes back in the 1920s when that statement was made. Well, it's gotten much worse since then.
So one of the things that were really terrific about America is they always said that we had the rule of law. Mm-hmm. And the idea was that citizens would have some kind of certainty as to what was the law and what was not the law. But what I think I hear you saying is that the law has been, how shall we say, corrupted, messed up, and so people cannot even know what the law is. Is that fair to say?
Well, let me give you an example. Let's take the area of the First Amendment. The First Amendment protects freedom of speech, freedom of petition, freedom of assembly. Pretty straightforward ideas. The Supreme Court invented a doctrine called the compelling state interest test. And basically this says that if there is a compelling state interest for some kind of regulation of freedom of speech, then that regulation will be upheld. Well, that terminology doesn't occur in the Constitution. There's no definition of compelling state interest in the Constitution. It's an extra constitutional, I would say a non-constitutional doctrine, unconstitutional doctrine. Well, who decides what that is? Well, whichever 5 justices agree, right? And the other 4 will say that it isn't compelling. There's no objective standard. There's no way to come back later on and say, well, if we change the composition of the court, we'll get the same result. In fact, if you changed the lawyers who argued the case, you might get a different result. It would depend upon what evidence they present or what arguments they made. I look at the whole thing and say, this is totally non-scientific. It's totally arbitrary. Well, how do you run a legal system on doctrines that are totally arbitrary, that one cannot predict with any kind of certainty will be applied in a correct and an objective, a reproducible manner?
Sounds to me, Dr. Vieira, this is something that transfers a lot of wealth to the attorneys so they can have something to do.
Well, that's right. It's an attorney benefit program.
Yeah. As you know better than almost everyone, one of the failings of the Supreme Court is in the monetary side. Mm-hmm. And one of the things that's been of great concern to me was the fact that Robert Bork, supposedly a strict constructionalist, recognized that the legal tender cases might have been wrongly decided, but came up with this notion of super precedence. The idea being that some things have just been precedent for so long and so much law had been built around them that we couldn't change them. What's your view about that? Is there a super precedent? I mean, if something's wrong, shouldn't it just be fixed?
Well, our Constitution is different from the British Constitution. The British Constitution was based upon, and still is, based upon precedent. If the king could usurp some power and lord that over the Parliament, he'd get away with it, and then that precedent would be used later to justify or rationalize the use of that power. And conversely, if Parliament could limit the power of the king in some way, and that was established, it became a precedent. In our system, precedents really don't mean much, or they shouldn't mean much. They're what some legislature may have done, rightly or wrongly, the decision some court may have made, rightly or wrongly, and the question is, if we compare this precedent to the Constitution, which is supposed to be the controlling element? It's not the precedent, it's the Constitution.
Exactly.
A decision of the Supreme Court is an opinion of the Supreme Court about the application of the Constitution, in a particular set of facts. It could be right or wrong. The Supreme Court opinion does not determine what the Constitution is. The Constitution determines what the Supreme Court should be giving in its opinion, or whether the opinion that it gave is correct or incorrect. Unfortunately, what we find taught in the law schools, and I went to Harvard, graduated in 1973, so this has been taught for decades, certainly, is that we look at Supreme Court opinions to tell us what the Constitution means. They teach the Constitution, certainly at Harvard and most other law schools, by the case method. You don't start by reading the Constitution and try to figure out what it means. You start by reading Supreme Court decisions on the Constitution.
So doesn't this mean, in fact, that we really don't have the rule of law here in this country anymore?
No, by hypothesis you have the rule of men, because, as I say, the compelling state interest test, which they apply again, not just in the First Amendment area, they apply it throughout the Bill of Rights area. That test is non-scientific, it's non-verifiable, it's non-falsifiable. Well, then what does it depend upon? Well, it depends upon the opinion of these 5 people, or as I call it, the fifth fool theory of the Supreme Court, that fifth one who could go from one side to the other. What's in his head at that moment determines the constitutional outcome. Well, if that isn't the rule of men or of women, I don't know what is.
It's not the rule of law, right?
It's not the rule of law.
So you had this line years ago, I loved it, and you said the living Constitution depended upon who was living.
Exactly.
Talk to that.
Well, the living Constitution concept is that the Constitution in some way changes or evolves over time. As social conditions develop, we have to interpret the Constitution in a different way than we did 20 years ago or 50 years ago or whatever. And that's all in the mind of the beholder, ultimately. The extent to which social conditions in a fundamental sense have changed, the extent to which the principles in the Constitution in a fundamental way don't apply to the new conditions, right? So the living Constitution, as that quip goes, really does depend upon who's living. Who's that fifth fool on the Supreme Court who's going to make this decision based on his own personal appreciation of social conditions, constitutional history, constitutional language, or what have you? And also, often you find that that appreciation results in a real twisting of the meaning of the Constitution, or even in using words that don't appear in the Constitution. They'll typically write an opinion saying, well, the Constitution says this, and it means this, right? And they've moved you away from the real meaning of the Constitution. Then on the basis of this new interpretation, which they've given it, now they apply that to the facts, and they come up with a result that someone who was versed in what's called original intent, that is, what did the Constitution mean when it was enacted? And it had to have a meaning when it was enacted, or it wouldn't be a law by hypothesis, right? We're no longer dealing with original intent. We're dealing with the intent of whoever it is that's sitting on the court, based upon what they think is good social or political or economic policy.
And since these Supreme Court justices are selected and confirmed by the politicians, doesn't this mean that the court has become politicized?
Oh, highly politicized. You look at the recent opinions in the Obama administration. Justice Sotomayor, Justice Kagan, right? Were those politicized? Look, you mentioned Bork, Professor Bork. His confirmation hearings, was that an example of a politicized confirmation hearing? I don't think anyone would doubt that it was.
Sure.
They wanted to know what his personal philosophy was, not the simple question, are you going to interpret the Constitution according to its original intent? Yes or no? Yes, we can put you on the court. No, we're not going to confirm you. They wanted to know what his personal philosophy was on all sorts of issues. And I would just shrug my shoulders, I don't care what his personal philosophy is. Is he going to follow the Constitution or not? But that is no longer, I mean, it's the same as electing a politician now.
Right.
They run on a platform.